Here's another one I get a lot. Client calls and says, "Hey, Steven, I need you to sue the auction." And I start laughing because it's almost impossible to do. I said, "Why do you need me to sue the auction?" And it always is something to do with the car wasn't in the condition I thought it was in, the disclosure wasn't right, the picture, I couldn't see a certain corner of it, or it broke down later, or it won't pass emissions, or I didn't get the title. A little bit of a different story, but it almost always relates to one of those issues. Well, the bad news is you can't really sue the auction for those problems. The auctions are protected, number one, by contract, but they also have an arbitration policy that governs almost every single auction transaction. The problem is most dealers don't take the time to read the arbitration policy, and by the time they decide to do something about the vehicle, it's too late. Most of these arbitration policies have very, very strict deadlines under which the dealer can make a complaint or try and reverse a transaction. Title issues can be a little different. They can have a little more forgiving, and some last years, frankly, if there are title issues. Remember that example I gave of the stolen car that was repossessed a few buyers down the road? That was actually 2 years later, and the auction reversed the transaction. So some title issues can happen later, but for the most part, most of the complaints arising from an auction sale must be brought to the auction's attention within 3 days to a week. If it's past that time, some auctions will allow it, but many have very strict policies that expire after 7 to 10 days at the longest. So any dealer that is going to start working with an auction must, really, really important that the dealer learn the auction's arbitration policy, and specifically the deadlines under which that dealer would have to make a report to the auction, or the deadlines under which that auction will take a report or a complaint and address it.